Welcome to Miranda Warnings Roundtable, discussing legal issues and current events. I'm joined on the roundtable by Liz Benjamin and Professor Vin Bonventre. Liz is the managing director at Marathon Strategies, a public relations and communications firm, and former host of Capital Tonight, a political and policy show focusing on New York State politics. And Professor Vin Bonventre, Distinguished Professor of Law at Albany Law School and publisher of the New York Court Watcher, devoted to commenting on the U.S. Supreme Court and the New York State Court of Appeals. It's 2025 session, although even though the session I thought ended, they're still issuing some decisions on its shadow docket. We're going to talk about that, the use of the shadow docket at the Supreme Court.
There's no shadow docket.
Okay, well, let's start with that. We'll start with that, Finn. Is there a shadow docket at the Supreme Court?
Well, according to Justice Alito, there is no shadow docket, but the last time I looked, there were 113 cases that were decided without oral argument, that were decided on an emergency basis. And 23 of those, the court actually divided. I mean, that's really something. You don't have oral arguments, you don't have full briefing, and it's a divided case. The court doesn't think that it's worth their time to actually hear the cases and give them full appellate process.
How unusual is it to have division in a shadow docket case?
Well, none of the administrations prior to this had 113 in 1 year, not even close.
But again, like, to be so divided, I mean, I'd love to, like, maybe they all hate each other.
What?
Well, because to be so divided on a case that you're not even bothering to argue sends a message that indicates disgrace. That you're not getting along too well behind the scenes.
It's a disgrace. Yeah.
Well, they just issued a decision in the case involving the Department of Education, which President Trump issued an executive order seeking to eliminate the Department of Education and fire most of the workers. That was enjoined. That action was enjoined in the First Circuit Court of Appeals, and then the Supreme Court now just reversed that without a decision. Yeah. It's the case of McMahon versus AFT, without a decision.
Because they have so much work, David. I don't think you understand. These guys decided 62 full cases this year. Well, there's 9 of them. They each have 4 clerks. They decided 62 cases. They're busy.
Even though there was no written decision in the majority, so we're not sure why they're letting the Secretary of Education dismiss all these workers. Justice Sotomayor had enough time to write a dissent and indicate that this was inappropriate, because you're not going to be able to put the toothpaste back in the tube.
As they're finding, I mean, look, this is an aside. Of course, it's not related directly to a decision by the Supreme Court, but as they are finding, and a number of areas that DOJ touched, where the Department of Health was like, oh, whoops, sorry, we didn't. When we dismantled that infectious disease department, maybe that was a really bad idea. Why don't you all come back? Right. And so it's difficult to do that. It's difficult to put the toothpaste back in the tube, et cetera. And you would think that that would serve as a cautionary tale for the court, but of course, no. And what this is really all about, and I'll just I'll say it now, and then I won't repeat myself like some sort of crazed minor bird over and over. This is all about the decision of how much power the executive, in this case, the president, has. And the court, by and large, not entirely, has deferred on the side of do whatever you want and come back and clean it up later. And to me, that's really a travesty. Nothing to do with politics necessarily, but to do with the balance of power.
Right, separation of powers. And Vin has looked at this, right? There's a number of cases involving the president, right? And you've looked at it empirically. So,
right, I looked at them. I put together all the cases that the court decided, full appeals, and the emergency applications. And Trump is winning about 65% of the cases now. Liz is absolutely right. There is a constitutional issue which has to do with the presidential power to remove executive officials. That's the issue on the merits. The other problem, of course, is that you have a single trial judge who's issuing these orders, stopping the operation of the federal government. Now, we've had some whack jobs that were appointed by Trump, and they were stopping the operation of the Democratic administration. And the Democrats didn't like it back then. Now, all of a sudden, Trump's president, and the Democrats, all of a sudden, they like to have this single federal district court trial judge stopping the operation of the Trump administration. That is a genuine issue.
It is a genuine issue, but I'm going to have to stop you when you say suddenly the Democrats think differently. We're talking about cases where the executive order is in direct contravention of what the U.S. Constitution says.
Well,
when we're talking about birthright
that's
citizenship.
an issue on the merits. That's your view. It may also be my view.
And I think most people who read the Constitution as well. So when you have a president that's running roughshod over the Constitution, and then you're saying, well, okay, you're going to have to, and this is in the birthright citizenship case.
Yes.
Now, every district court, you're going to have to bring a lawsuit in every district court, and it's only going to apply to the people that bring the lawsuit. That is.
Well, that's not necessarily true.
Well, that's what the court said.
No, Justice Kavanaugh, concurring opinion, made it clear that there can be class actions that are brought, right, in a federal district court. If, for example, a particular state brings an action in a federal district court.
Class action.
The district court.
Class action.
No, if a state brings an action on behalf of the citizens of the state, that order of the district court will apply.
Which has been happening with alacrity, right? Like the attorneys general have been banding together to sue, including ours, to sue over all number of things: release the education funds, protect individuals against ICE raids, like all sorts of stuff. I mean, just to go back though, this is again a philosophy and an approach that this administration has been applying across the board, going back to the very early days of the administration. Doge before the Musk-Trump fallout, which I don't know where that stands at this point, but they were very clear in saying, we're going to do so many things all at once, all the time, that you can't keep up with all of them and you can't fight all of them. So the idea that you would make a decision to say, okay, yes, you still have the legal right to challenge, but you have to challenge in a piecemeal basis is a way to make things as difficult as possible, and something somewhere is going to get through. Right. I mean, that's an underlying foundational philosophy of this administration.
Well, that's true. But don't forget, in the Casa case, by the time it got to the Supreme Court, there was one issue, and that was the universal injunctions by a single federal trial judge. The issue of birthright citizenship was not before the court, right? I mean, the court could have gone out of its way and said, well, we're going to handle this issue, the substantive issue anyway. But that was not the issue before the court. And Amy Coney Barrett made it absolutely clear this is not about the merits of the birthright citizenship issue. It's purely, do we allow one trial court judge to issue an order, right, that holds up an entire branch of government?
Is this the moment where we're going to have for Amy Coney Barrett? Do you want to have the moment now?
Yeah, well, I've been saying I think Amy Coney Barrett is a heck of a lot better than the Democrats were giving her credit for at the beginning. She's bright, she's measured, she's temperate, and like I said before we went on the air, she's actually voting with the liberal justices, which I gather we all like. She's voting with them more than anybody else on the court.
What about she's voting consistently with Roberts? Most of the decisions she votes with the three liberals. It's a 6-3.
But she's been voting with the liberals even more than Roberts.
6-3.
Yeah.
I'm sure you have some empirical data.
Yeah, I do.
Yeah.
Other than my anecdotal.
Again, we also talked about this, but this is not terribly surprising, even though the MAGA universe is probably angry at her.
Oh, they hate her.
But just, again, we talked about this earlier. There is an historic precedence for this, which is that you say what you have to say as you go through the hearing process, and everybody is like, we expect you to do this, this, and this. I mean, her record was not terribly long, if I remember correctly.
Right.
So there wasn't a lot to go on.
Pretty conservative.
Yeah, but it wasn't voluminous.
Like
she was also young, comparatively speaking.
She did not look like a nut
No,
job.
I understand, but they were expecting certain things from her vis-a-vis the litmus tests and the very carefully constructed arguments that she made without saying very much, which they're all coached to do in the hearings and the private conversations that they have with senators. And then you get on and there's no way to get you off unless you die. And so you just, are unfettered to do whatever it is that you think is the right thing to do, which clearly she's doing. And that makes people angry.
Yeah, absolutely. Yeah.
Yeah.
But she's
not the first. She probably won't be the last.
She's not the first, but there haven't been that many recently because the presidents and their advisors, right, have really been looking at track records. She actually had a pretty conservative track record. Again, not a nut job, but certainly had a track record which suggested she was politically conservative and strongly so. And none of this is to say she's not a political conservative. She is.
Yeah, but
her voting record is conservative.
Yes, but then again, I mean, she didn't have to make decisions on the level of import that the court is now dealing with. So where she was before, she's
nobody
dealing
ever
with
does.
The constitutionality and the balance of powers question, and what it is that if a person, as the Constitution says, is born here to parents who are not from here, that person is considered a citizen. That seemed to be sort of unquestionable from a legal standpoint, and now, of course, is being bended. So those kinds of decisions, you can't predict how a person's going to act based on their record because they've never had to wrestle with things of that nature before.
Of course, but most of the justices, a recent appointment, have been sticking to what has been expected of them. Now if you listen to Chief Justice Roberts at his Senate confirmation, if you thought he was going to be a far right winger, you were missing what the guy was saying. He didn't suggest, there was nothing to suggest he was actually going to be like
You're suggesting that political true believers have selective hearing, which I would
well,
agree
sometimes
with. I agree with that statement.
They hear what they want to hear, whether that's the Republicans or the Democrats. The Republicans thought he was going to be absolutely atrocious. Republicans thought he was going to be excellent. The Democrats thought he was going to be atrocious. None of that turns out to be true.
He's been both.
Yeah, which
is encouraging, frankly, right? It's an encouraging thing to see people who then have, I don't want to say the courage of their convictions necessarily, but who feel like a certain protection once they get on the court, and they feel a certain protection because you really can't get them off. And so as a result, then they feel that they can actually make decisions that they are reasoned to do.
Yeah, there was a commentator last year who said this really isn't a 6-3 court anymore. It's a 3-3-3 court.
Yes.
And there's a lot of truth to that.
Makes it so much more interesting.
You've got Roberts, you've got Kavanaugh, and you've got Barrett. Yeah, and those are the deciding voters.
As those three go, that's the way the court goes.
Right.
And what kind of empirical data do you have that shows that? Is that
it shows they by far are in the majority. They're in the majority by far among the justices on the court. You can imagine that Ketanji Brown Jackson, Sonia Sotomayor are in the majority the least, as are Thomas and Alito. Yeah, the two extremes on that.
So what does that tell you about the court, where we've got Chief Justice Roberts,
right,
Amy Coney Barrett, and Brett Kavanaugh? Those are the ones that are, for the most part, taking the court.
That's right.
Where it's going. That's, although it's not the most conservative, that's a relatively conservative core.
But they,
right? Even though they're in the middle of the court.
They're in the middle of the court. The middle of the court, the center of gravity of the court has moved to the right.
But they also haven't been charged with making any, I'm checking myself as I say this, like purely political decisions of a nature that can bend the arc of the future of the current president. For example, if
presidential immunity?
Well, yes, that one. But also like the possibility of him seeking a third term, right? His discussion about like, maybe I'll seek to change the rules, and maybe I'll seek to stick around, and maybe I'll do all sorts of things.
Well, birthright citizenship is up in the air. Why not a third term?
Why not?
Yeah. Right? Why not? I mean,
but to be clear on birthright citizenship, at least according to the Amy Coney Barrett, who we were just discussing, she says that they didn't actually make a decision.
They did not make a decision, but there are several justices on the court who look like they're going to vote the way Trump wants them to vote on birthright citizenship. That is against, right, undocumented foreigners coming into this country and having children, and those children would not be citizens. There are scholars and there are justices on the court who agree with that view.
I would like to know where these individuals think that we're going to get all of the workers that we need, since we don't have them.
Oh, you mean as a
I'm just
real
saying,
practical-
since we don't have them here to do the jobs that individuals who are here and documented don't want to do.
Well, it's not, I mean, that's a good question, but it's not a policy issue, right, for the court to consider.
Not yet. It's
only,
not.
The only thing the court needs to consider is, interpreting the Constitution. And the Constitution is clear that there is, in fact, birthright
Do you
citizenship.
think the Supreme Court interprets the Constitution?
They can read it.
Are there words
read
in
it?
the
I think they are.
Constitution that decide these
I think
cases?
this one says if you're
This one seems
in the
to.
14th Amendment.
This one seems to. The fact that, or the law that Trump cannot seek a third term, that seems to be clear.
Oh.
But virtually nothing else is clear.
But this one is. This one
Well,
is.
you and I think so.
And most, I think.
Yeah, but if they decide it in a way that is contrary to what appears to be clear, there's nowhere else to go unless
Right.
Congress intercedes.
Canada.
Well, Canada, right. But there's no higher power above the Supreme Court to which we might appeal the decision based on what the words say or don't say, unless Congress intercedes.
Right.
Passes new legislation,
But
which
what the
would then have
words
to be
were
signed
intended-
into law by the president, who would not sign it into law, which is a circular place that brings us
what
back.
the words were intended to mean. And when the Supreme Court decides cases contrary to what the words were intended to mean, if it's in a liberal direction, we celebrate, right? But the court has done that throughout its history all the time. In virtually every decision landmark of the court which we cherish, they have gone beyond either the text or the meaning of the text.
Yeah, but
right?
it's interesting though, even though they have not yet weighed in on the question related to the future of birthright citizenship, the chilling effect that is already in place based on the possibility that they will or won't is something that's a problem. Similarly, the LGBTQ book case, right? The parental choice case is really about something entirely different than just whether or not you have to have your kids sit in a reading circle on a book that may address an issue that you don't like sexuality, or I don't remember what the other one was. One was about sexuality, and I can't remember what the other one was. But the problem is the separation of church and state. The problem is interpretations and a chilling effect on education. I mean, there's a whole series of issues that will be born of a decision that has far-reaching implications of the possibility that the court might weigh in further.
Well, in that case, the Mahmoud versus Taylor is the case involving the opting out, parental opt-outs for certain types of books based upon religious objections. And in this case, it was
Parental rights.
gay and transgender
Yeah.
characters.
Gay and transgender.
But I think the overriding legal issue is whether states can either permit or prohibit this, and that was the same thing in the.
Well,
the
it just, again, as
medical.
an aside, you think this state where we're supposedly championing liberalism and a progressive
Who,
value system,
New York State?
we have
Not nearly as
banned
much as
issues
many
in
other
this state.
states.
We have fights going on right now in this state over public libraries and what they can and cannot, school libraries rather, and what they can and cannot carry. And I'm old, but I remember when I was in public school, there were kids who were pulled out of sex ed. There were kids who were pulled out of the daily academic rigor to go to religious instruction. And they missed whatever it was that was scheduled for that particular time, so they could go to a different room or a different building and receive whatever religious, it was part of the agreement, right? And this was happening, and I'm old, and this was happening 30, 40 years ago. So this is not a new
You were
conversation.
alive 30, 40 years
I know, it's
ago,
crazy.
Liz?
It is crazy.
I was already old, but I'm surprised you were around.
I was.
No, look, we have to talk about parental rights because that's that's the basis for some of these decisions. And I love the fact that David's favorite justices, the originalists and the textualists on the court, they've discovered parental rights, which, oh my God, it's not mentioned in the Constitution. It's not even insinuated in the Constitution, but somehow they have found it there, right? They have found it there. And for a long time, with regard to the rights of minorities, the view was insular and discrete minorities who have suffered discrimination. Oh, what about LGBTQ persons? No, not them, but white persons. Oh, yeah. Now, equal protection was intended to protect white persons. I mean, things have just turned around.
I know this is not on your to-do list, so it'll be a dramatic departure. Right. But getting back to the implications and the ripple effect, if you will, the affirmative action case, which was decided 2 years ago, is that right? 1 year ago, 2 years ago?
Students for fair admission.
Right. So that arguably was part of the decision that Columbia made to just settle with the Trump administration for $200 million so they could get back their millions, hundreds of millions of dollars in federal grant and research funding. But part of what they agreed to was to hew to the U.S. Supreme Court decision related to not using race based in their admissions process, which already was the law and they weren't supposed to be doing anyway.
That is constitutional law. Columbia should have been abiding by that. Do you doubt that Columbia was using racial preferences?
I don't believe that they were overtly using racial
preferences. Okay. Yeah. So whether we like it or not, that is now the supreme law of the land. Racial preferences cannot be used in college and university admissions. There's little doubt in my mind that Columbia and some of these other schools were using racial preferences. That happens to violate the law now. And the Trump administration loves the law the way it is now against racial preferences.
Yes, but then they use like a game of Jenga because they weaponized subsequently funding that goes into, saving people's lives against various different diseases, et cetera, and other funding that goes into potentially questionable, or I wouldn't say questionable, potentially offensive in the mind of the Trump administration grants for psychological research or historical research or what have you. But the medical research, depending on the topic, seems to be the most indefensible area where you would be cutting, right? Because you could really say people's lives are at stake.
They're skeptical of science.
Yeah.
Yeah. I mean, look, years ago, you might have been in kindergarten.
No.
But years ago, I think it was 1972.
Not kindergarten.
There was a case before the United States Supreme Court where there was a challenge to take away federal benefits from some religious schools down in the South. Why? Because they discriminated on the basis of race, right? And this was, it was the policy of Nixon not to give them federal benefits, Carter not to give them federal benefits, and then your favorite president, Ronald Reagan, decided to withdraw the Nixon and Carter briefs and decided to side with the religious institutions and to allow them to continue to discriminate on the basis of race and to receive the federal funds. Chief Justice Warren Burger, speaking for the court, I think it was an 8-1 decision, said, no, the federal government is not going to provide benefits to an institution that is violating fundamental constitutional law in this country. Well, the Trump administration, I'm just talking about legally. I'm not talking about, how wonderful they are. But legally, they have pretty secure footing with regard to going to these Ivy League institutions and saying, if you're using racial preferences, the supreme law of the land is you're not allowed to. So
what's their fundamental argument against defunding Planned Parenthood then?
What's their fundamental argument against?
Well, no, or for rather. In other words, if ostensibly the argument is the law of the land is X, and you are violating the law of the land, and so therefore we're defunding you, and we have strong legal footing to do it.
Well, the argument is that now the states get to decide, and what they're saying is now the states can decide whether they want to fund that or not. Right? So we crossed that bridge with Dobbs, where it said, the states are allowed to decide what kind of rules they have in their particular states
Right.
regarding.
So previously, the argument
It
could
would
have
have been
been
wrong
this
previously.
removing the funding is infringing upon a fundamental right of a woman to choose, but you don't have that argument anymore. And the argument that you have now, the strong one, is that between the Congress and the president, they get to choose where to spend federal tax dollars.
And I think but more to Liz's question, I mean, the issue now is whether the states can stop funding. So when you're talking about Planned Parenthood, a very small portion of what their funding goes to is actually abortion. A lot of it is medical health care, obviously. I'm not going to.
The bulk of it, you can't use Medicaid funds to fund abortions.
But the problem for Planned Parenthood is they're saying because a little small portion of this goes to funding abortions, we can cut all the rest of your funding, because if we pay you for that, then you're just going to use the money that you would otherwise have for abortions indirectly. So for left pocket, right pocket. So they're not only using the Dobbs decision to stop funding abortions, they're using it to stop funding other things that are non-abortion medical work that Planned Parenthood does.
But look, if you get 5, you can do anything. You know that.
So it's just a numbers
good
game.
And bad.
It's just a numbers game.
The court is a numbers game? Yes.
Yeah,
of course it's a numbers game, because contrary to what you were insinuating earlier, David, 95% of what they do has nothing to do with interpretation or translating. It has to do with choosing between legal arguments, which are pretty darn close, and choosing a particular side. And they choose the particular side because of whatever wisdom they have, or practicality, or workability, those kinds of things.
I understand that, but what I was referring to before was actually
pretty clear.
Was actually
it is pretty clear. No,
I wasn't referring to.
She's getting back to.
No, I agree with you. No, I agree with you on that. But what fun would this show
I wonder
be?
what it sounds like when you don't agree.
I agree. Can you imagine a podcast? I agree. Liz, I agree.
Well, maybe we could all do it in time like this, and that would be kind of interesting for a few minutes. Maybe.
I think we all agree. This was great that we got together.
It's wonderful to see you
great
both.
that we got together. But what about the reputation of the court?
What about it?
What do we
have? What do we have?
No, I'm getting to that.
What do we have?
Let's talk about reputation.
I have to give.
I mean,
I have to give several CLEs 3 hours long. I need something to talk about.
Well, I mean,
okay. Do you approve or disapprove of the United States Supreme Court? Approve 40%, disapprove 53%. That just came out.
Are those?
That just came out. Quinnipiac poll.
Proof of how they're voting, or of having a Supreme
handling its
what
job.
Percent?
They give it generous.
Of voters said, "I don't know what is the Supreme
7%, only 7%. But I'm sure it's at least 50% that really don't know.
The idea that the average American
don't approve.
53% do not approve. Okay. Now, how do you think this? Do you think the Supreme Court is motivated by politics or by the law? 63% by politics. You win. There you go.
I lose.
I think it begs credulity to suggest that the average American is paying a whit of attention.
No, I'm just talking about the reputation. That has nothing to do with accuracy.
You need to know what the Supreme Court is in order to say.
You need to know what the public is thinking, but that doesn't mean it's accurate at all. Yeah.
I don't think that anybody has any.
You could pull your law school class.
Oh, you could do a survey monkey of the CLE. Do that.
They should be paying attention.
Yeah, this past summer, the school asked me to teach con law, so I taught con law.
Oh, that's a fun one.
A bunch of flaming liberals they were this summer. I had to keep acting like I was conservative. You know?
That's tough for you.
Well, actually, it's not tough at all. I think I'm pretty conservative compared to who? Compared to academia nationally, I think I am.
Oof.
I'm a traditionalist.
That's a loaded statement.
Well, academia is.
It's not about you, Ben.
What?
It's not about you.
I know it's not about me.
It's all about you.
Sometimes it's about you.
So did you ask these questions of your summer school
absolutely.
students?
Oh, yeah.
And
what did they say?
Was it
Well,
higher than the national average?
The difficulty in law school is that the conservatives oftentimes are afraid to speak up.
Yeah.
They're afraid to speak up. So you hear from those who don't like a conservative Supreme Court, who don't like a Trump.
That's a travesty of
You
higher
don't
education.
hear
I have
so
to say.
much from the students who might think it's fine. You know.
Yeah, that's a real failing of higher education, that people who have dissident views don't feel safe to express them.
Oh, absolutely. Absolutely.
I feel that right here with the two of you.
Oh, you invited us. I just want to be clear. This was an invitation. You knew what you were in for.
I'm happy to see you both. Hey, so in closing, what are we going to see? What more of the same coming up in the Supreme Court?
Liz?
Better? Worse? Improved?
Do you think that the possibility of the president seeking to remove the Fed chair before the Fed chair's term is up gets to the Supreme Court?
Look, the constitutional issue with regard to all this has to do with whether or not, in technical terms, this is a superior executive official or a lesser executive official. If it's a superior or principal executive official, the president gets to remove that person at will. If it's a lesser one, that is one that does not make policy for the president. The president doesn't necessarily have the constitutional authority to remove
The
that.
Fed chair makes policy for the entire nation, including the president, arguably.
Yes, but the Supreme Court in a different era would say the Fed chair is appointed to be independent. Right. Just like independent counsel, the independent prosecutor, they're intended to be independent. And they actually have a narrow jurisdiction. He can't make policy on LGBTQ rights, on affirmative action, on the death penalty. He can't do that. It's on one limited area. So you can
say the economy is not limited.
It's extraordinarily powerful. That would be the other argument. That would be the other argument, that the practical consequences of what the federal chair does.
So the reason why
extraordinary. That's the argument before the court.
It was a circuitous way of getting around to the answer to the question. Like, it really depends on what comes before the court. So you're saying, what will we see? Will we see more of the same? Will we see something different? Will we see? I mean, I would like to see. I wouldn't like to see. That's a terrible thing to say. It would be interesting to see how this court would rule, given the 3-3-3 situation that we talked about earlier, if the question of Jerome Powell's, continuation came before them. Other issues that might come before them that we cannot at this moment foresee, I think will determine how it is that they go forward. As of right now, with all things being what they are, I would say more of the same, but maybe not. That's what's so interesting about watching the court.
Yeah, absolutely. The court has already decided certain issues that are analogous to this. So the president does have the authority, it seems that the court has ruled, to remove members of the National Relations.
Right.
National Labor Relations Board. Does have the authority to remove the chair of the Consumer Protection Board.
Right.
These individuals are supposed to rule independently, but the court has leaned in favor of presidential power on these.
But in those cases, they, in dicta, admittedly, they said Fed is a different animal.
Yes.
Right. So they said the same standard that they was permissible in that they held the Fed in a different standard.
Yeah. Yeah. You're absolutely right. It's the three. You got to look for those three. You got to look for those. And every once in a while, something pops out of Gorsuch's hat and he votes the way you might want him to vote.
Well, you might want him to vote, not the way Trump might want him to vote. That's a different conversation.
Thank you both.
Thanks for having us.
I missed you both. We'll see you soon. We'll have you back soon. This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.